You guys didn't think I was done with Dan Wootton, did you? Oh no. There's an article here from Byline Times a couple of days ago that I haven't covered, and I'm going to bring it to you now, guys. Let's go. Good morning, good afternoon, good evening, wherever you are in the world. This is REGANELITE here with an article from Byline Times with the headline that disappearing Dan Wootton articles shows a serious need for S4 alternative. The major publishers remove articles about the Met Police investigation into the presenter after receiving legal threats. Following Byline Times' special investigation, the CEO of Press Regulators in Press sets out what could have been done to prevent such a situation. So this is essentially about the mainstream media are basically ignoring this story, intentionally and deliberately ignoring the story. And the question is why? Why are they ignoring the story? And it doesn't. There's clearly something going on here, and it seems Byline Times may have figured out what that is. They're obviously afraid of consequences of action, perhaps being taken by Dan Wootton and his legal team potentially. I have to stress, and I've stressed this on all the videos, and I'll stress this here, these are all allegations against him. If despite the fact that there is quite a lot of evidence against him, they are still allegations, and we have to stress that. But this has not been going. This is not going to go away, and I'm hoping Byline Times doesn't let it sweep under the carpet. The fact that the Met Police are now investigating it should be a need for the mainstream media to at least highlight this, and we don't understand why that's been the case, and it does put into question the integrity of the media in the United Kingdom, and that's for sure. The influence of the rich and powerful over what can and cannot be published in the UK is long-standing and often rooted in a broken system, but it is not an unfixable problem. Last week, so this was on the 11th of October, just for reference, guys. So last week, The Guardian and The Mirror, various other Reach sites, and The National removed stories after a legal warning made by a lawyer acting for suspended GB News presenter and former MailOnline columnist Dan Wootton, following the Byline Times investigation into his conduct and subsequent Metropolitan Police investigation. In a response, a spokesperson for The Guardian's media group told Press Gazette bluntly, following a review, the article has been taken down. What? I wish I could have had this article and just seen what The Guardian had read in it. That made it be dangerous. The basis for such legal threats is often along the lines of a police investigation triggers a right to privacy, with the 2022 decision of Bloomberg LP versus ZXC, where the Supreme Court found pre-charged suspects have a reasonable expectation of privacy, invariably cited. Coincidentally, this seems to be on the basis for guidance issued by the Attorney General following the reporting on the Russell Brand allegations. Some think in Press has recently moved to clarify in a letter Victorian Prince's case too. While an awkward teething phase can follow new legal proceedings which limit press freedom, this is instance any reasonable explanation of privacy. Dan Wootton, who denies criminality but has never denied being or being connected to false online personas, may hope to have enjoyed pre-charge. It's not absolute and can be eclipsed by another powerful legal position, the public interest. The public interest is a fluid concept ultimately decided by judges and regulators, but offers a broad protection to journalists and editors when it is interpreted in good faith. This latest retraction of news covering across high-profile archives reveals that these news providers were not persuaded and that there was a strong public interest defence in the Wootton reporting, although seemingly strong enough to publish in the first place, or that the legal threat was sufficiently chilling that they caved and removed the stories. He's got his hands in his pockets in some powerful people. There's absolutely no question about that, because the thing here, this is the bit here, that the legal threat was sufficiently chilling that they can't remove the stories. So they knew it was a big enough story to put in their newspapers. The question is it really, what was the real reason why these papers took the story away? That's the real question there. You see here, there's a number of stories here. Without a doubt, legal threats can be presented an existential challenge to news publishers. Litigation's costs are, on average, $750,000, and most legal cases can now take years to be resolved through the courts. Even if an editorial team stands behind an investigation, the spectre of litigation can collapse a new business. And even more now because of the frailty post-digital news business model. However, this is not a new phenomenon, and sadly, legal threats from powerful interests who do not want to be held to account by free and independent journalism are par for the course. In the absence of coherent regulatory infrastructure and political leadership on press policy, the new atonement of research and inquiries, both at a national and international level, have been unleashed to find a remedy to this age-old problem. Early solutions have been left wanting, tinkering at the edge of civil court procedures, which presumes news publishers and claimants can afford a day in court, even after passing through the costly pre-litigation Lady Brief, where the first legal writs arrive in the inbox. Frequently, however, they cannot, and at this point may bow out to the process before lawyers and their litigants get involved. A real solution would address and weed out the roots of the problem. Number one, people, including journalists, are not well versatile in the legal and ethical issues arising from publishing, particularly online. Number two, zealous and vicious litigants on both sides feel empowered to threaten and bluster because of a broken legal system. And three, the absences of political leaders with the courage to put forward bold press policy reforms that support free and independent press journalism. Press policy is now an elephant graveyard. Most regard the only legal incentive left, the executive commencement of Section 14 of the Crime and Courts Act 2013, as dead on arrival. The Conservative Party politicised it, and after 9 years of posturing, it found a legalisation vehicle to repel it. Meanwhile, Labour seems minded to oppose its repeal, although an official stance has yet to be taken. The legislation intended to reduce the burden on publishers, only allowing people to sue if a publisher rejects independent self-regulation, and also gives ordinary people who couldn't possibly afford to sue a newspaper without the judicial discretion to make unregulated publishers pay for the cost where judged for it was fair to do so. Access to justice. So what is the alternative? In the past 10 years, none of the bright minds of media policy or lobby has come up with a variable alternative proposition, and the situation has deteriorated to such an extent that it is needed a facelift from the new form of a new acronym. A threat such as that from Wootton's camp is in territory of a new trendy polymaker slap, strategic lawsuits against public participation. As a regulator, we've tried so many threats and separate from wheat from the chaff, and only allow legitimate claims to go forward. We have been able to provide publishers and claimants with assurances that our processes will be fair and transparent, and enable many news publishers to stand their ground when they believe in the legitimacy of their journalism, and alternatively provide effective redress when they got it wrong. The result: no publisher regulated by Impress has been successfully sued in the courts. A future in which publishers are protected by the threats of expeditious and deliberately legal fees, and where the Wootons of this world must go through an independent body rather than targeting individual newsrooms. It is not possible, it's working in action. We must continue to be fought for. If we want to see fewer arbitrary takedowns of legitimate journalism, we must build on systems of self-regulation already underpinned by law, rather than being held back by the current policy approach that lacks the courage or vision of our news past, and that our news future dependently needs. This is from Lexi Colonel-Koroska, of the CEO of the press regulator Impress. Guys, it's a very worrying thing that it is important that the media and press are able to do their jobs, but obviously there is also that line of when is it too encroaching? Is this information needed something to be regarded to the public? And in this case, the public have a right to know about this story. Now, in the end, if it proves to be that Dan Wootton is completely and totally innocent, rightfully so, the media should apologise outright, to him. But that's not the case right now, as of the time of this recording. And the fact that they have taken down stories on him has put into the integrity and the question of those medias, because that something has happened that has made them want to take those stories down, and we don't know what. And how many instances where there have been stories where they have stories or articles or whatever they are, of very important knowledge that the British public must know, and they've been told they can't do it or take it down because, not because it isn't newsworthy, but because of threats from powerful figures or politicians or any sort of reason that could be deemed a threat to them. There may be more stories about the Conservative Party that we don't know because the government have issued an iron fist on some of them, possibly. So there is that to be made as well. So there is reform does need to be made of some sorts within the media to ensure that free press is allowed to flow, because we don't have complete and total free press. I think if we did, I think there'd be a lot more scandals probably being more out and about, in my honest opinion. But what do you guys think about the media's choosing not to cover the Dan Wootton? Why do you think they did this? What do you think is behind this? Do you agree with my assessment? Let me know what your thoughts are on all this down in the comments section down below. And if you want a reminder, I will put a few links in the description to remind you of the story about the Dan Wootton investigation. There's a special live stream you guys can check out that I've done a while back on it as well. Thanks very much for watching. Take care as always, and I hope to catch you all very, very soon.